The following is a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys. The Siniard Law Show, answering your legal questions, featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. You can call 844-7000-LAW to leave us a voicemail with your question, or you can email us at questions@siniardlaw.com. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley. They're focused on giving back to the community through legal education. They've got almost 300 five-star Google reviews and an A+ accreditation by the Better Business Bureau. Tonight we're discussing workplace discrimination, harassment, and equal opportunity claims. Bart Siniard and Eric Artrip are here to give you details and answer your legal questions. Bart, please introduce us to Eric.
Yeah, I'm really glad to have Eric on set. Eric is one of the premier, if not the premier, employment litigation attorneys in North Alabama. And he's been practicing 28 years here in the Huntsville area, practices all throughout Alabama, and really focuses his work on employment discrimination, harassment, retaliation type cases. He's had big verdicts in that arena, had one last year, I know, for 7 figures, and then one almost 2 years ago for multiple 7 figures. So he's the guy I call when I have questions on this, because I don't do a whole lot of this. He does. So I'm really glad to have Eric. Eric, thanks for being on the show.
Thank you very much for having me. I'm looking forward to answering whatever questions we get.
Yeah, as far as I know, we've not tackled this topic yet, so this ought to be really exciting.
No, we were looking through email questions we've received, and I noticed a trend, and we need to address some of these, and that's what we're gonna tackle.
Well, good. We have a lot of them, so let's go ahead and get to it. Now, if you have questions on tonight's topic or any legal topic, just email us at questions@siniardlaw.com or call us at 844-7000-LAW and your question may be featured. Now to our legal tip of the week, equal employment opportunity claims. So guys, what is the EEOC?
The EEOC, and I'm so glad Eric's here to kind of give us a rundown on this. But it's where the process starts. If you feel like you have been discriminated against, and that you got to do that to get the ball rolling in order to pursue any type of employment discrimination case. Eric, if you could just walk us through the basics of what the EEOC is and the process of making a claim through them.
Yeah, sure, no problem. So the EEOC, or just like you said, the Equal Employment Opportunity Commission, every state has one. Ours happens to be in Birmingham. Doesn't really matter where it is because it's all filed electronically. But if you have a claim of disability discrimination, gender discrimination, or race discrimination, you have to go to them first. Allow them an opportunity to investigate the claim, and then ultimately they will issue what's called a right to sue letter, which is kind of your ticket to ride in federal court.
Mm-hmm. But you can't file a lawsuit until you go through that process.
That's right. Yeah, it's what they call an administrative remedy.
Yeah.
And you have to go through that first before you can't just haul off and file suit. You've got to go to them first and again give them an opportunity to open a dialogue with the employer and see if there's some kind of resolution that can be reached that doesn't involve litigation.
Don't they have a mediation program? Can you walk us through what that is?
Right, very briefly, they do have a mediation program, and that's a situation where if both parties, both the employer and the usually former employee, agree to go to mediation, then you'll sit down with an EEOC mediator. It's free of charge. There's really nothing that can be brought up later in a lawsuit about what arises during the mediation. Really good program. And sometimes we do get cases resolved there.
Gotcha.
So when should somebody file a claim, and can you explain the importance of acting quickly in these cases?
Right. One of the biggest things about employment law is the short window of opportunity. We're all familiar with statute of limitations, that idea that after so long, can't do anything. For the EEOC or these claims, it's 180 days. That's not quite 6 months, it's a little less than 6 months. So it makes it imperative that if people feel like they have been discriminated against, call the Siniard law firm, call somebody, get some advice on where to go from here, because you don't have a whole lot of time on these cases.
And what about preserving documentation? How important is the documentation and hanging on to it?
Unfortunately, so many times when people are fired, their access to their emails is immediately revoked. Mm-hmm. So what we try to tell people is, go ahead and get the latest version of your employee handbook. Go ahead and get any relevant emails, as long as you're, obviously legally entitled to them, but forward them to a private Gmail account. Then even if you get dismissed, you'll still have access to those documents.
That's a really good tip. Let's go ahead and get to one of our viewer questions. This is an email from Melissa, and she says, I believe I've been treated unfairly at my work because of my gender. I've been passed over for promotions while less experienced coworkers were promoted instead. How do I know if this qualifies as discrimination, and what steps should I take before filing a complaint?
I think this is a good time to kind of walk through what are the legal elements, so to speak, of what a lawyer has to prove to win a case. Could you walk us through that? I always tell people in what we do in personal injury, it's like a recipe, proving negligence or recklessness or willfulness. You have to prove several things in order to have a valid claim. And just like in what we do, personal injury, when Eric's representing a victim of workplace discrimination, he has the burden of proof. He and his client have the burden of proof. Can you walk us through what you have to prove in order to have a chance to win a claim like this?
Sure. Again, very briefly, obviously you and I can prove any case in only one of two ways: direct evidence or circumstantial evidence. Direct evidence is, Deborah, we're not letting you go to this training, or we're not letting you go to this seminar. We're going to take all the men. We really just think a man is in a better position to handle this. That's direct evidence of gender discrimination for our purposes here. Mm-hmm. But so often, these employment statutes have taught people what not to say. Mm-hmm. So then we have to fall back on the circumstances surrounding the decision and see if we can derive that intent. So for us,
we call that like pattern and practice type
exactly,
evidence.
Yeah. 100%.
Walk through what that is. And because direct evidence in what we do and what you do, I'm sure is harder to come by. Yeah. It's rare where you will find an email that says, we're promoting Jason over Melissa because he's a man. Okay, you probably never see that.
Most people know.
You never see that. Yeah. You rarely see a smoking gun like that, if ever. Walk us through the pattern and practice type evidence that you use to support a discrimination claim.
Yeah, sure. In our scenario, like she's asked, like the viewer has asked for here, we would look at things like how many men are in her position. Are they being treated differently? Is she being disciplined for something that the men are not? Is there a pay disparity? Those are the kind of things that we would point to, I think, if we are trying to prove that she's being treated differently because of her gender.
Yeah, and I know it's hard to get a lot of that info.
That's what I was going to say. How in the world would you get other people's salary unless somebody tells you or know that that's accurate information?
Eric, I think, has to have a hunch that he's going to find stuff.
Right.
But really, I'm assuming the only way you can get that usually is in the litigation process.
You're 100% right. Yeah, a lot of that stuff is behind the wall of the litigation. Now we can get to it once we're there, but getting to it at the EEOC level or when they first come into the office can be a challenge. But we listen to the stories and see if we can help them, and we do if we can.
All right, let's get to another question. This one comes from David. He emailed us saying, my supervisor frequently makes inappropriate jokes and comments that make me uncomfortable. I've reported it to HR, but nothing seems to have changed. At what point does this become workplace harassment? And what are my rights if my employer doesn't address it?
So I get this question a lot from clients of mine. And harassment in and of itself, is that enough to bring a claim? And how do you define harassment legally?
Well, in the world where we live in, the 11th Circuit, it's pretty hard actually to have a harassment claim.
Yeah.
Just a few off-color jokes and things like that, they won't cut it in this circuit. Mm-hmm. But if it changes the conditions of employment, then you can pursue a claim. In this instance, this person is complaining to HR. What I would say is to make sure that those complaints are documented. In other words, make sure those complaints are in writing.
Right.
It doesn't, you can still make a complaint verbally on the phone, but even then I would probably follow up with an email documenting that.
Yeah, I mean, and we've talked about it on the show on a variety of different legal topics, is particularly when you have the burden of proof as a party to a dispute, you sometimes have to create the evidence yourself through a paper trail. Telling somebody something on the phone or in person, there's no evidence of that, and that could be considered hearsay, or it could just be, it's not great proof because it's a he said, she said moment. So I always recommend in any kind of legal dispute, whether it's, you're in a dispute with your homeowner's insurance company about whether there's hail damage to your roof, or whether, you've got a dispute with a nursing home about care that they're providing your mother. Do it in writing and save it, whether it's email or old-fashioned letter or whatever, something that's tangible that a lawyer can later use to prove what they need to. He said, she said conversations, while maybe admissible evidence, just don't carry the weight that a document does.
We need to hurry and get to this next email, but I'm so curious about audio recording.
Does that ever come up in your cases? I'm sure it does, where, you have a client who maybe people aren't believing her about some discrimination and records something. Can you do that?
Is that admissible?
Yeah.
Yeah, I mean, in Alabama, we're a one-party recording state, of course, which means as long as one party in the conversation knows it's being recorded, it is legal to record it. More importantly, it is admissible. So we often will tell our clients to record conversations when they see the handwriting on the wall that they're about to be dismissed. Mm-hmm. Because those recordings can be very valuable to us later on down the road if the employer or the employee of the employer disputes what was said in that meeting. If they dispute it, then there's a recording. It's certainly better for us.
Mm-hmm. Okay, how about this question from Angela? She says, I recently filed a complaint about discrimination, and now I feel like I'm being treated differently at work. My hours were cut and I'm being left out of meetings. Could this be considered retaliation? And what should I do next?
So, yeah, I mean, this is a common problem. A lot of people are scared, I'm sure, to report what they feel like is discrimination or harassment because of potential negative consequences. What do you see in your experience with people who are brave enough to report discrimination and then have some negative consequences like her, where hours are being cut or demotions or whatever? How do you handle that as a lawyer?
Well, it's very similar to the way we would handle the initial, hostile work environment or discrimination, because under most of these acts these federal laws that we prosecute under, there's the laws about anti-discrimination, but then there's a whole separate section of that same law about retaliation. Recently, we had a guy came in and he had complained about his supervisor mistreating some of the women in his office or their office. And the supervisor brought him into the conference room and said, well, I need you to have my back on this. And he said, well, if I'm asked, I'm going to tell the truth. And he was immediately handed a termination notice.
Yeah.
So that's the kind of thing that is definitely retaliation and would qualify for some kind of treatment, I think, under the law. You'd have to go to the EEOC first, right. But it's a case.
Wow. All right, thank you so much, Eric and Bart. When the Siniard Law Show returns, we'll get to more of your legal questions, and we'll tell you how you can sign up for the Siniard Law Firm's free monthly newsletter.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
North Alabama's best attraction is not its mountains, or its rivers, or even its rockets. It's our people, honest, hardworking people, who make us proud to do what we do. When people in our communities are injured in an accident,
we help them fight insurance companies based in big cities far from here.
We are honored to help people get the compensation they deserve.
Siniard Law, nationally recognized, locally trusted.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, scan the QR code or sign up at siniardlaw.com. Now let's get back to you, our viewers, and your questions. Here's an email from Chris. He says, I was wrongfully terminated shortly after raising concerns about workplace discrimination. How do I determine if I have a case, and how long do I have to file with the EEOC?
Yeah, so Chris has, similar question to some of our earlier questions. How do you know if you have a case? And we've kind of walked through that. But what are like the elements? I mean, you're trying to prove, let's say it's race-based discrimination.
Sure, yeah.
What is like the legal standard? Like what is good enough and what isn't good enough in regards to proof? And I know there's vagueness there, but walk us through that if you would.
Sure. So they're handled under the balancing. It's a balancing test. Mm-hmm. So what we say is, to begin with, I'm part of a racial minority. I was treated differently from my other race colleagues, because it protects workplace minorities. So anybody, both Caucasians, African Americans, Hispanics, no matter what. But I was treated differently because of my race. And that we hit the ball over the net. Then they hit the ball back to us and say, no, that we have a legitimate non-discriminatory reason for the action we took. Okay. And then we have to hit it back again and say, that's pretext, or that's made up. Mm-hmm. You're trying to cover your tracks for doing something that is wrong. Yeah. So it kind of goes back and forth.
So it sounds like you hit the initial volley. They almost always hit back. Right. And then it's that third volley where you're trying to meet your burden. And what is the legal burden? Is it preponderance of the evidence, or how is that?
It just like you and I both are basically on the same thing, where we're both on the plaintiff side of things. We have the burden of proof, but it's preponderance of the evidence. So it's 51%. So just a little bit more true than not. Mm-hmm. And it really comes down to the credibility of the people involved, it seems to me. So.
Yeah. Credibility of witnesses is incredibly important.
Absolutely.
And that we mentioned earlier in the show, is there written evidence or audio evidence? Yeah. So, his question, how do you determine if I have a case? And how long do I have to file with the EEOC? So let's walk it back a bit. If people feel like they may have a case and they want to contact a lawyer such as you, how does that process work? And how are you paid on the case?
Well, if they were to feel like they have a case and they feel like they've been discriminated against or retaliated against, they would probably pick up the phone with you, and then you would often call me, and we'd work together on the case. But we're not going to be sending a bill to that client for the time we spend working on that case. Mm-hmm. We're going to be paid on a contingency fee basis, just like you are. Yeah. In other words, we're going to be paid as a percentage of the recovery at the end if we recover anything. Yeah. Our firm operates very much like yours. As expenses come due, we pay them. We write a check for them. We ask to be reimbursed at the end, but only in the event we actually recover something. Yeah. So you and I are on the same boat on that deal. If there's never a chance for the plaintiff or the employee to write a check to us, there's either money coming from us to them, or there won't be any money. Yeah. So
it's very similar, identical, really, to personal injury law. You know, free consultation, and the client pays nothing unless they're winning and getting money themselves.
So what about if you kind of sense something like this is brewing at your workplace? Is it a better idea to hire the attorney or come consult one of you guys before you're terminated, or to maybe get some guidance on what you can and can't do in terms of collecting evidence?
Yeah, do you call a lawyer while you have suspicions, or should you call a lawyer after you've already been kicked to the curb?
We certainly appreciate it when they do call us ahead of time, because that puts a lot more clubs in our bag or tools in the box, whatever you want to say, but it gives us more options. One of those being we can send an email to HR and we ghostwrite those a lot.
Yeah.
And those can be helpful. So.
Yeah.
And then that way the problem may magically vaporize, right? While you're still employed. Our next viewer question comes from Jessica. She asks, what kind of evidence should I be gathering if I believe I'm experiencing harassment or discrimination at work? Are emails and text messages enough? So I don't think we've yet introduced the idea of text messages. What about that?
Do you ever get that as evidence in a case, text messages amongst, I guess, coworkers or?
We see those more in the context of sexual harassment cases where a man, typically a man, is sending inappropriate text messages and sometimes pictures to his female colleagues.
Yeah.
And that can be obviously qualify for sexual harassment, and that's where we see those things a lot.
Yeah. And we're kind of taking a turn on the topic, but you handle those sexual harassment cases in the workplace setting.
We do, yeah.
And I've seen some high-profile cases you've been on in the news. What do you have to prove in that context? Say, hypothetical, you're a female, your boss is a male, you feel like, flirting with you, coming on to you, sending inappropriate messages.
Right.
When does it rise to the level of being a valid lawsuit?
Well, like I mentioned before, our district, our circuit here is pretty strict as far as those kind of things go, but we certainly know them when we see them. Mm-hmm. The women come into us, typically all women, although we have represented some men from time to time, but they come into us, and if it changes the conditions of employment, they really do. It seems like, they get in their car every morning and it feels like they're going to jail. Mm-hmm. It's like, what am I going to have to put up with today? What's going to be said to me? What am I going to have to, fend off? What is he going to say? What are they going to say? That kind of thing. And at that point, then we think that rises to the level that would qualify for sexual harassment, even the conservative 11th Circuit.
Yeah.
What about pregnancy cases or somebody, needing maternity leave or something like that, and they feel like their job changed or, it's not the same, or, things like that are really subtle?
Yeah, I've looked into that, and it is murky. What are pregnant women's rights when they are coming along, and because I've seen this more than once, the lady who requests FMLA or whatever, they let her go. What are pregnant women's rights or young mothers' rights in regards to employment status?
Well, you did mention it, the FMLA. That's an important one for us. As long as they've been there at least 1 year, they are entitled to some time off to care for the child when it's very young. Mm-hmm. Also, they can't really discriminate against women just because of their pregnancy. They can't fire them or shift them into a lower paying job or something along those lines. Mm-hmm. Also, Alabama, curiously enough, is one of the few states with a Pregnancy Discrimination Act on the books here.
Yeah.
Governor Ivey signed the Alabama Pregnancy Discrimination Act, I believe, in March of 2026. So it's a relatively new law, but it does cover just the things that we're talking about, how you have to treat women who are pregnant just the same as if they weren't.
Eric, while we have you here, I want to talk briefly about FLSA, because you don't just do discrimination and harassment and sexual assault. There's Fair Labor Standards Act case, and I know you've handled some of those. Can you walk our viewers through what that is and what that entails?
Sure. The Fair Labor Standards Act, just like you mentioned, does deal with pay in the workplace. It requires at least the federal minimum wage for every hour worked. That sometimes comes into play when people are, they have to show up maybe a half an hour early to get into their uniform. Pardon me, that actually has to be compensated. So, and then if you have to take another 15, 20 minutes to get out of your uniform, that has to be compensated as well. Training has to be compensated. And then of course, any hour worked above 40 in any given work week, that has to be paid at time and a half.
So if an employer's not paying you what they're supposed to, say you've been working 8 hours overtime a week for, years, and you're not getting paid that, what are the damages, so to speak? What can you go after the employer for? Is it just back pay, or is there more you can go after? What does that look like?
It's kind of limited because you can request the pay you missed out on times 2.
Okay.
So you can get double that. And if you can go back 2 years, but if you can prove that the employer intentionally knew they were doing wrong, you can go back 3.
Okay.
And you can get that doubled.
Okay.
Also, a little bit funny on that one, like lawyers can't get paid out of that pay.
Okay.
We also can't charge FLSA clients an hourly rate.
So how does a lawyer get paid in an FLSA violation case?
The only way we can get paid is by the employer paying us and our hourly rate times the time that we spent working on the case.
Wow.
Also, a little bit funny and different from most of our cases, FLSA settlements, if we were trying to settle the case, they always have to get court approval.
Okay.
So no matter what, we always have to go to a federal judge and ask him or her to approve the settlement that we think is fair.
How often are you seeing those FLSA cases? Is it getting more frequent, less frequent? Or is it about the same?
It's tough to say, but I will say that we just took in a case, and I won't mention the employer, of course, but it was a fast food joint, and the manager was just going in and shaving people's hours a little bit. 30 minutes here, 10 minutes here, an hour there. And they were shaving it down so that they wouldn't have to, they could keep their labor costs in line. But that's not fair to the employee. And so we're going to try and see if we can help those folks.
Yeah. Does that ever end up, I know you've also handled some class action cases. Do any of these case types we've handled that we've talked about tonight, did they ever end up in a class action setting? And if so, walk us through that briefly.
Sure. The two kinds of collective actions. The FLSA has its own kind of collective action rules. And you can send notice to every one of the employees and say, if you feel like you've been cheated on hours, then you may have a claim. Also, sometimes, how we were talking about the women's claims when they weren't afforded the same opportunities for advancement or employment, or training rather, those can end up being class actions and sometimes have.
Interesting. All right. Thank you, Bart Siniard and Eric Artrip, for all of this information about workplace harassment, discrimination, and EEOC cases. We look forward to hearing from you, our viewers, with your questions about any legal topic. You can email us at questions@siniardlaw.com or call our voicemail line at 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.